My name is William Trackman. I am the General Counsel here at Mountain States Legal Foundation, and welcome to our monthly So a Neighbor Asked webinar series. This month's topic is So a Neighbor Asked, what Supreme Court cases should I be watching this term? We are excited to have two senior attorneys with us today from Mountain States Legal Foundation to talk about the cases that you should be watching, both the ones that have already been granted, one of which has already been argued, and then also what cases are pending that the Supreme Court might opt to take in order to review them and make a decision in those. So let me introduce our guests in addition to myself. To my left, I have Ivan London, who is a senior natural resources attorney here with us at Mountain States and has litigated any number of cases in the natural resources, the energy, the land use space, and a lot of those topics are before the Supreme Court right now. And then on the screen with us here today, we have Mike McCoy, who is the director of Mountain States Center to Keep and Bear Arms. Mike joined us earlier this year and has jumped into the deep end on a number of very important high-stakes cases involving the right to keep and bear arms, including one case where he was in the Supreme Court just earlier this month in the VanDerStok matter about homemade firearms. So we have quite a bit to talk about. As a reminder, there is a Q&A box, and we will have time at the end for Q&A. So if you have a question, don't be afraid to drop it in that box, and we will do our best to get to it before the end of our time. We're going to try to go about 45 minutes. Hopefully, I won't be too long-winded, and we can cover all the cases that we want to cover in that time. Mike, let's start with you. You're the man of the hour in the VanDerStok matter. Why don't we talk about, number one, how the case got to the Supreme Court and why people ought to be watching the matter of Garland v. VanDerStok?
Sure. It got to the Supreme Court because we won repeatedly, which was good. And the government, specifically the ATF and the DOJ, didn't like that. So we won at the district court level. We won at the Fifth Circuit, and the court, or the DOJ and the ATF, filed a petition for cert to the Supreme Court, which was granted, and the case was heard, as you mentioned, just earlier this month. Just to give background for those who are not familiar with this case deals with the ATF doing what it's tried to do under the Biden-Harris administration multiple times, which is take the role of Congress when it comes to regulating firearms and firearms-related activity. In this specific context, it was related to unserialized firearms, and specifically firearms that are made at home, privately made firearms, and firearms that are made from gun kits, which have not been regulated in the same way by Congress as commercially available and commercially produced firearms. And Congress has repeatedly over the last 50 years refused to regulate them in that same way. And so they're not required to be serialized. They can be bought and sold without background checks being conducted and various things like that. The ATF has referred to these firearms using the pejorative term ghost guns, to make them spooky, I guess, and even more scary than they are. But the reality is these firearms are, generally speaking, made by law-abiding citizens, almost always made by law-abiding citizens, and almost always used by law-abiding citizens. And that's borne out by the crime stats. Although the ATF and the government, the Biden-Harris administration, wants people to think that these unserialized firearms are being used more and more in crimes throughout the country, that's really not the case, and the statistics show that. I think in a good example is Philadelphia, where of the approximately 5,000 firearms that were seized in Philadelphia in 2020, only 13 of them were believed to have come from gun kits or been privately or homemade firearms, basically. So it is a problem, or it's a solution looking for a problem. There is no problem there, but it's the desire and the effort of the ATF to try to regulate every aspect of our Second Amendment rights, and in so doing, whittle those rights down as much as possible. So they're going after rewriting rule after rule after rule and trying to see if they can sneak by these regulations, which they effectively are, that Congress has specifically not authorized, and in fact, in many cases, has said, no, we are not going to go down that road. So the ATF has gone down that road. We filed suit against them. The case went all the way up to the Supreme Court. It was argued just 2-3 weeks ago now, and we're hoping for a good decision on that case.
Yeah, VanDerStok is the only case that we'll be talking about today that's already been argued, and you were at the argument I'd love to ask you just one or two questions about it. It seemed to me like the Solicitor General, who was representing the ATF in this case, was arguing a lot about the consequences
Mhm.
of the ruling, either about the idea that criminals are going to get their hands on guns, or that if they rule in favor of our clients, that every gun will become a ghost gun. I mean, I think you just addressed the merits of those arguments. Are those legal arguments, or are those more like
No.
policy arguments that you would address to Congress?
They're policy arguments, and to some extent, they're sort of the means and balancing test that the Supreme Court has in the past and in other Second Amendment cases said that's you can't do that, right? The Second Amendment is a constitutionally protected right that we have, and because of that, the court has repeatedly said there is very rarely going to be a justification that's going to basically allow for the authorization of a regulation that infringes upon people's Second Amendment rights in various different ways. And our hope here is that this is one of those areas where the court says this is going too far. And on top of that, it's interesting. This really wasn't a Second Amendment case per se. It was a separation of powers case, or it is, I should say, since it's still going on. And the argument here is, hey, you know what? If you think that these homemade firearms should be regulated, if you think privately made firearms should have to be serialized and background checks should have to be performed before gun kits are sent to people, fine. Go to Congress, right? That's the whole point of our system. It is not the executive branch's role, which the ATF falls under, to regulate or to legislate. That's Congress's role. And the reason why the founders set that up is because Congress is composed of the elected representatives of the people who are closest to the people and have the ear of the people. And so because of that, that's who should be legislating on this front. So go to Congress if you think this should be done. Don't do it on your own. And ultimately, that's the thrust of our argument that we presented to the Supreme Court, that it's really a separation of powers issue. And don't get distracted by this, this sort of gun control crime policy argument that the Solicitor General is making and the ATF has made throughout the entire pendency of the case.
Yes, by all means, go to Congress, but of course, Mountain States will be there to sue Congress when they do the same thing. So
Yes,
let me ask you one more question about the oral argument, and then I want to talk about one of Ivan's cases, which is a lot of people are trying to draw inferences from the questions at oral argument. And one thing that struck me was both that Justice Alito was asking very probing questions, but even Justice Kagan, who is a Democratic appointee, was asking at least one or two skeptical questions of the government. What do you make of the idea that you can predict who's going to win based on what questions the justices ask at oral argument? Is that just a fool's errand?
I think so. And I think, a lot of times everyone's trying to read the tea leaves of the questions they're asking and see is there some reason why they're asking that particular question. And sometimes it is because it sort of gives away their cards, right? And this is how I believe. And I think some of the justices may have done that, particularly Justice Jackson, and some of her question, which was more of in my opinion, more of a narrative, not really a question, where she was basically laying out what's likely her belief in this case. But generally speaking, with the other justices, their questions were definitely open-ended and definitely open for broad interpretation as far as where they're going to fall on this thing. And I think sometimes justices ask questions that make it seem like they're falling on one side of a case, and a lot of times they're not. They're just simply trying to bolster what is likely a rebuttal that's going to come from someone else. And get the evidence and they need in order to push back when it comes time to make a decision when they're in the room together and arguing the case amongst themselves or deliberating on it. So
Yeah.
I don't think there's really anything you can read too much into it. I'm told, I didn't listen to the oral arguments in Cargill, but I'm told that people walked away from those oral arguments, a bit concerned about how the court might rule. And yet the court ended up ruling 6-3 in our favor, in favor of the Second Amendment. So because of that, I think we just have to hold tight and wait to see what the decision is. And trying to guess at it or predict it at this point is, to your point, a fool's errand.
Yeah. You mentioned Cargill. That's the bump stock case where the ATF decided that it would be against the law, it'd be a criminal act to have a bump stock. And much like our case, the challengers said that exceeded the power of the agency and sued and prevailed.
Yes.
You mentioned Justice Jackson. It seemed like she wanted to relitigate the issue of agency deference. She said, shouldn't we just defer to the ATF here? And of course, that goes to one of Ivan's cases about agency deference and the fact that they already decided a case literally this year rejecting agency deference in the Loper Bright matter. With that, Ivan, let me turn it to you. You're watching some cases that haven't yet been argued this term, one of which I think is the Seven Counties case. Can you tell us a bit about that case and what you're looking at?
Yeah, absolutely. And we're not just watching them, we've been participating in these cases too.
Of course.
And I'm glad that Mike flagged the separation of powers components of some of these cases. Certainly there are direct constitutional or very clear constitutional questions about what does the actual amendment say, for example, Second Amendment. And then there are the other kind of more structural constitutional questions regarding what Mike referred to as separation of powers. And Seven County fits right into that theme. As Mike said, there's a question whether Congress gets to decide things as the most directly elected representatives when it comes to what's in the public interest. What are our laws? What should our laws be, and what do they mean? And from there, what can the federal regulators who implement those laws do? And Seven County brings that straight up. So the background briefly, and we can go on for a while on that, but the background briefly, if you follow oil and gas, as I do, there's a very prolific basin in eastern Utah, the Uinta Basin, that is basically kind of separated in large part from the rest of the United States as far as ability to access the area if you are invested in oil and gas, get oil and gas out of there. Although there are many other reasons to be connected to that area, or people in the area want to be connected to the rest of the nation. And so a conglomerate of entities, public entities included, put together a proposal for a rail line, a relatively short rail line to connect to the national rail system to help get products in and out of the area. Primarily it'd be oil and gas from that area, but there are other issues that involved too. And it had a broad elected representative support both at the state and legislative level. Now, Congress in this case, Congress has said that building rail lines is in the public interest. So what does that mean? That means that we should understand that as a nation, we've decided that building rail lines is generally in the public interest, presumptively even in the public interest. Of course, there's another set of laws that I'm sure people on the call would understand called NEPA, the National Environmental Policy Act, which Congress put in place to make sure that the federal regulators looking at questions like, should we build a rail line, take a breath, consider and explain to the public what the environmental implications of building a rail line might be. In this case, that's exactly what happened. There's a proposal to build a rail line that would connect the Uinta Basin to the rest of the country. The regulators, the federal regulators at the Surface and Transportation Board, the STB, looked at this. They put out hundreds of pages of documents explaining the environmental impacts that might or might not occur from the project, not just the building of the rail itself, but kind of the maybe tangentially related aspects of it. And then decided that it's in the public interest to build a rail line like this, and the explanation on the environmental issues isn't determinative under the laws that Congress put in place, and frankly, they're all manageable. So the STB, the board, approved the rail line. Now, at that point, the entities that had argued against the rail line, and some of them, for example, were in Colorado, one of the main respondents in the Supreme Court cases, Eagle County, Colorado. They had originally gotten involved because they didn't want a train with an oil car on it going through the mountains of Colorado near their town or in their county. But they really transformed into a question of, well, what does the STB or any other agency have to do with regard to predicting hypotheticals about what might happen with climate change if, for example, this rail line at some point enabled future oil and gas production? Assuming there's oil and gas production, where in the world would refineries produce that product or develop that production into usable products? And the STB said, look, we appreciate these questions and we're going to try our best to answer, but we have some limitations on what our knowledge is and frankly, what our authority is. We couldn't even change some things if we wanted to because we don't have the legal authority. So this is one of those cases where the federal regulators at issue kind of did things, what I would say, the right way. That did not survive, though, appeal to the circuit courts, where a circuit court set aside the decision. based on the idea that there were tangential environmental impacts that had not been considered thoroughly enough. So cancel the whole rail line, set it aside, vacate it. Now that had been appealed to the Supreme Court. We got involved last spring to advocate for a trade group that was involved, or interested at least in it, the American Forestry Resource Council, that has similar issues coming up in timber projects and has dealt with these for decades.
Because otherwise, it would be the end of the road for that.
It'd be the end of the road, and we wanted to advocate the Supreme Court should take on this case. It very rarely takes on NEPA cases, even though they affect so many projects, especially out here in the West. It's been literally decades since they have done so, and it might be decades since they do this again. And luckily, or fortunately, I guess, in the summer, the Supreme Court agreed to review the case. And so we got involved then again early this fall for AFRC and for our friends of the Western Energy Alliance to help again advocate for the merits of why the Supreme Court should look at this seriously. Congress in many places, both in the various forest-related statutes, in the Mineral Leasing Act that applies to oil and gas, has made very clear that doing these things is in the public interest. But at what point can any given regulator or maybe a federal judge, respectfully, can they put other interests above the public interest as Congress has explained it? And that's what the case is about. And so that's fully briefed, and the details in that case, it'll be argued this coming December 10th.
Excellent.
Obviously, we'll be watching it and hoping for a good result. And so that's that case for sure.
So by contrast to VanDerStok, where we prevailed in the district court and the appellate court, and the government asked the court to review it, and it's a federal regulation, so kind of a no-brainer that the Supreme Court ought to take it. This is a big deal. The Supreme Court reached down to the lower court and said, we want to review this property rights interest, separation of powers case. They're taking, 65, 70 cases a year, and this is the one they decided to get involved in.
Yeah, and those of us who are involved in Western lands, energy, natural resource litigation, of course, we deal with the National Environmental Policy Act all the time. And it's one of these statutes under which the lower courts for decades, including in my practice for a while now, court doesn't know what to do sometimes. And so it'd be great to get guidance from the Supreme Court to the lower courts on what exactly the lines are, right? What are the standards? The question that was granted is somewhat narrow, but it could be interpreted broadly, and we'll see what the court does.
I have a great tagline for you, which is that NEPA doesn't mean no. What do you think about that?
Yeah, I'll write it down right now.
Okay, thank you. I can see that you're not.
You can see that, right? Yeah. We'll workshop it. I'm not against it. Yeah.
All right, Mike, back to you. We've got another one of these cases where the Supreme Court reached down to the lower courts to take a case where the challengers had lost in the Second Amendment space. This is a case involving the country of Mexico and the company Smith & Wesson, where Mountain States not just watched, but got involved and urged the court to take this case and review it in order to set the law straight. Do you want to give us a little bit of background on the Estados Unidos case and what issues are at play? Yes,
and I'm known for ranting, but I'm really going to rant on this one. So throw something at me when you want me to shut up. It's one thing when we have various blue state governments trying to find unique ways to undermine people's Second Amendment rights, and they've been doing it more and more through lawsuits. So they're trying to do that, obviously. But to me, it's another thing when a federal or a foreign government actually tries to get involved in shutting down the American firearms industry, which is exactly what's happening in this case. The country of Mexico has decided to file suit against Smith & Wesson and various other American firearms manufacturers, alleging that their business practices have contributed to the drug cartel's crime in Mexico, and therefore caused damage to the country of Mexico itself. And so they have sought injunctive relief. Well, first of all, they're suing for billions of dollars of damage, which would basically bankrupt many of these companies. And on top of that, they're asking for injunctive relief. A foreign government's asking for injunctive relief, which basically would require the courts to force these companies to stop making rifles, to stop making magazines that hold more than 10 rounds of ammunition, and various other things that would basically just completely dismantle a large section of our firearms industry. And the reason they're trying to do this, and they're being encouraged and helped by anti-gun groups in the United States is because they want to find new and creative ways to somehow attack the Second Amendment, thinking this might be a good resource and a good avenue for doing it. But again, it's a foreign government that is coming in and trying to undermine our Second Amendment rights. And it's never good, regardless of who's trying to do that. But it is particularly irksome to me that we have other countries basically trying to undermine a constitutionally protected right that we all receive as Americans by the mere fact that we're born in this country. And so that's the problem. This case was filed in federal district court. The district court immediately said or ruled that it was a violation of the Protection of Lawful Commerce in Arms Act, which was a piece of legislation that Congress passed a long time ago, which basically said that you cannot hold firearms manufacturers responsible for people using those weapons or those firearms in criminal activity, right? You can't hold them guilty for the bad acts of somebody else using that firearm for that particular purpose. And Congress was very explicit in that legislation to say this, our point of doing this is to make sure that these companies are not made insolvent through lawsuit after lawsuit, and that they are there and present in this country so that people have the ability, not just on paper, but in practice, to buy firearms, to buy ammunition, and successfully execute their Second Amendment rights. And so that's why Congress passed that piece of legislation. And the district courts, yeah, this lawsuit is barred under the PLCAA. And Mexico filed an appeal to the First Circuit, which is likely ninth, kind of out there in the middle of left field, literally. And the Ninth Circuit found a little exception and basically overturned the dismissal and said that the case should proceed, arguing that there wasn't that Mexico had established that there was a proximate cause between what the firearms industry was doing and what was resulting, the criminal activity that was resulting in Mexico. I think it's an extremely tenuous argument. I think the Supreme Court agrees with that. At least I hope that they do. They granted cert very quickly. The petitions were just filed over the summer. They granted cert on October, I think early October, October 4th. And the parties are now in the middle of briefing the matter. We have previously filed an amicus brief encouraging the court to grant cert, which they've done. So we helped get this case. And I have firm confidence the Supreme Court will overturn the First Circuit's opinion and uphold the district court's decision in this case.
Oh, that's good. That's breaking news. I like your confidence. So
that and a bag of chips will get you a bag of chips.
Yes. We were just talking about how we can't predict based on oral argument, but we can predict
yes.
based on our
I can see in the future. And but it's such a clear, the First Circuit's rationale is so ridiculous that I just don't see even the liberal justices buying off on it, but
that's great. Good.
Yeah.
Well, I'm going to talk about one case that's in the equal protection sphere, where the court has also reached down to the lower courts and decided to hear the case. Before I do that, just a reminder that there is a Q&A box on your screen. If you have a question about one of the cases we've talked about, or one of the cases that you're interested in that's coming before the Supreme Court, go ahead and drop it in the box now. So I'm going to talk about Ames versus Ohio. This is an employment discrimination case, and it involves relatively ordinary facts about how an employee argued that they were discriminated against by their employer. Run-of-the-mill garden variety employment discrimination case. What makes it unusual is that the Sixth Circuit, where this occurred in Ohio, has a very different standard for what a plaintiff has to do when they come to court if they're either a male or they're white. And those pleading standards are designed to say if you're part of the majority, that is, by the demographics of numbers, it would be really unusual for an employer to discriminate against you. And so we want you to meet extra pleading standards. We're going to talk about extra circumstances in your employment that make sense in order to get this claim past the first hurdle. Now that standard, it's in Ohio. It's also in Colorado, where we have the 10th Circuit. And it's applied to our clients just as much who are white, where the court says in order to get past a motion to dismiss, you have to give me something extra based on the race of the litigant. We saw this case coming a mile away. We have been in touch with the counsel for the employee. The employee filed a petition for certiorari after the Sixth Circuit affirmed this standard. The Supreme Court took it and oral argument is going to happen either this term or next term, more likely this term, although things can get delayed based on briefing schedules. But this really will be an opportunity for the Supreme Court to say the race or the sex of a litigant ought not affect how the court treats that litigant in their pleadings. And it really is an opportunity for the court to expand on the Harvard decision that was issued last year. Talk about how we're a colorblind society and ought not, especially our courts, ought not be treating people differently based on race. So that case has been granted, but not argued yet. So keep on the lookout for it. Ivan, let's talk about one of the cases that hasn't been granted just yet, in a different posture, not even really an appeal, but an original petition asking for leave to file a lawsuit in the Supreme Court by the state of Utah. Give us the details on that one.
Well, it's a very stretched transition to say it's equal protection in some form or another. It's very stretched. But it's a case that has come up recently. It's been brewing though for a long time among the Western states, which is a question that many have had in those Western states for a long time. Why does the federal government get to regulate so much land within state boundaries out here in the West? Is there some constitutional basis for it? And for a long time, there's been a suggestion that no, under various clauses of the Constitution, most predominantly the property clause of the Constitution, when states entered statehood, including the West, U.S. government, the federal government, had to dispose of its own holdings to those states. I said it's been bubbling for a long time. A lot of Western states feel this. In the past summer in August, the state of Utah filed an original proceeding at the Supreme Court, asking the Supreme Court to take a case on this. Now, so it's not dissimilar from the certiorari process we've talked about before, right? Where you ask for permission. Procedurally, it's slightly different because it's basically an original case. In a way, the Supreme Court would be the trial court. Also, there's an argument that under our Supreme Court would have to take a case like this, but I'm not, if we're talking about gambling on results here, I'm not sure they would feel the same way about having to do that. And frankly, if they were to deny it, I'm sure we'd not get an explanation.
Right.
But the point is that it probably is a very interesting case that the Supreme Court might take. Been filed. The state of Utah has filed a lawsuit against the United States, or asked the Supreme Court if it can file a lawsuit against the United States at the Supreme Court, arguing that under the Constitution, the federal government should have disposed of unappropriated Utah lands within Utah to the state government of Utah for its own management of those lands. Now, unappropriate, it's kind of a key term there. Yeah. Again, we can get in the weeds, but I don't want to do that quite yet. Basically, lands that aren't national parks, they aren't military bases, they're just kind of general federal lands that, for example, under FLPMA, the Federal Land Management Policy Act, the BLM regulates now for multiple uses, hopefully, and sustained yields. And this question goes to the kernel of, can they even do that? Now, the point of our involvement in this, and we are involved in this, is that, like I said, it's been an issue that's been brewing for a long time in the Western states. It hasn't really been dealt with. Arguably, there's one Supreme Court case that does that. But this is a new take on it. And so what we did was, for a group of Wyoming legislators, 20 plus Wyoming legislators, we filed a brief asking the Supreme Court to take this case. It's not just a Utah problem. It's a Western states problem, including the Wyoming problem for sure, right, where the federal government, works, I guess, to manage almost half the land in the whole state, and almost 70% of the mineral estate in the whole state. And so if kind of the whole mechanism by which the federal government means to do that is wrong, I think we do know that the Supreme Court, this current version of the court, will take on that tough question sometimes and not be shied away by saying it's the way things have always been done, if it's just unconstitutional. And so, like I said, we represent a group of Wyoming legislators in asking the Supreme Court to take on that case. Now, there's not going to be an immediate result here. The federal government has not even responded yet, and they don't have to until right before Thanksgiving. So I know there are a lot of people watching this case, certainly in the Western states. It'll be a very interesting case. And again, I hope they take it. If they don't take it, I hope we get a reason why, although I'll be surprised if we.
We just filed our brief last week, right?
That's right. We just filed our brief last week. And so there will be some time before we have an idea whether the Supreme Court takes this case. I would be surprised, maybe in an ideal world, it takes it, in the spring, and we get some sort of movement on it, by early summer. So I don't want to oversell the timing, but It is pending. It is a very interesting case. It's been a brewing issue for a long time, and we're certainly hopeful that we've helped convince the court that it's not just a Utah problem. There are a lot of entities, a lot of states in the West who suffer this too, and the court should take the case and resolve it.
Yeah, I mean, I view this as truly a 50-50 because they have a great litigator at the top, Paul Clement,
sure.
the former Solicitor General, but it's always hard to tell whether the Supreme Court's going to grant leave to file an original action in the court. You know, there's a whole case called Marbury versus Madison where they said we won't take an original action if it's brought by a person. Now the question is, if it's a state saying we want you to take this, they get to decide one way or another whether to take it, and sometimes they do it, rarely, and most of the time they don't. So we shall see.
Well, I want to flag one thing real quickly, just in case we have any of the legislators in the audience or others who are following the case. Utah limited its complaint specifically to the unappropriated federal lands, which I think is an important point.
They're not asking Yellowstone.
That's right. That's right. Yeah. There are groups out there who would maybe want to challenge those two and say, hey, look, you don't have the right to even designate a national park or a military base. So that's an open question that's not directly resolved by the motion for a case itself. It's more of these general tens of thousands, millions of acres, literally millions of acres across the western states, where the federal government says, well, we can regulate what goes on here. Yeah. And the question is, are you sure? Or why? And this is a really good case, hopefully, to really put that under the microscope.
Yeah. So let's talk about two other cases to watch that have not yet been granted. One is the Mountain States case, Advanced Colorado versus Griswold. And then, Mike, I'll turn it over to you in a second for the Aloha Spirit Hawaii case that I just want you to flag for a minute. So in Advanced Colorado versus Griswold, Mountain States is representing petitioner Advanced Colorado. Advanced Colorado is a local group here in Colorado that runs tax cut ballot initiatives. And there have been some successful tax cut initiatives on the Colorado ballot, reducing the state income tax by a point or half a point or some increment that have successfully gotten the voters of Colorado to reduce their taxes. Advanced Colorado wanted to run one of those measures this year on the November ballot, but unfortunately the state of Colorado, recognizing that they didn't like it when people paid less taxes, enacted a bill that required poison pill language on those types of measures, pejorative false language like, do you want to reduce education, healthcare, judicial functioning, public safety in order to cut taxes by 0.5%. The client, Advanced Colorado, argued before the trial court and the 10th Circuit that that was unfair, that you can't attach this pejorative poison pill language to their ballot initiatives, and that it was compelled speech. The lower courts rejected that argument. We filed a petition in August of this year, and in good news, just earlier this month, the Supreme Court ordered the state of Colorado to respond to that petition, which is an important first step before the Supreme Court decides whether to hear a case or not. The government has already asked for an extension in order to respond to our petition, so we shall see what happens there. We're hoping that that will be granted for review. You need only 4 justices, and our position is just that you can't completely immunize this language on the ballot by calling it government speech as opposed to compelled speech. With that, Mike, let's talk about the Aloha Spirit case just for a minute in terms of the fact that it's pending. We filed a brief urging the court to take this case out of Hawaii involving Second Amendment rights.
That's correct. So the case originates from a hiker in Maui who was hiking at night with a handgun that he brought for self-defense because he was concerned about running into animals or things along those lines. They unknowingly trespassed on a rancher's land who called the police. The police came, and when the police showed up, the hiker admitted, hey, I have a firearm. Well, in Hawaii, you can't possess a firearm without getting a license first. And sort of an interesting side note, of the 14 people who applied for a license in Hawaii the year that Mr. Wilson was arrested and charged, not one of them was granted the license. So anyways, he was charged with possessing a firearm without a license, even though it was being used for self-defense, and he challenged the constitutionality of that statute, that state statute. The lower court agreed, and it ended up going to the Hawaii Supreme Court and said, no, the Hawaii's Constitution's Second Amendment, or version of the Second Amendment, the right to bear arms, only applies to the militia, not to individuals. which is obviously completely counter to what the court ruled in Heller. And on top of that, they not only snubbed the court's Bruin decision, but effectively refused to apply it. Referred to the decision as backward looking and not applicable, or applicable only to a time when mostly white men were in control of the eastern seaboard of the United States, and not at a time like today where the United States crosses and includes islands in the middle of the Pacific Ocean. Some pretty inflammatory language and a lot of poking in the Supreme Court's eye by the Hawaii Supreme Court, our Supreme Court's eye. And so because of that, we've seen this trend repeatedly where lower courts are openly refusing to apply the Bruin analysis, which basically, for those who don't know, requires before gun regulation can be upheld as constitutional, it requires the proponent of that regulation to be able to link it to some sort of historical tradition, some sort of analogy at the time that the founders were ratifying the Second Amendment in 1791, or even at the time that they were ratifying the 14th Amendment in 1870, 69 or 70, excuse me. But after the Civil War, other than those two timeframes, you have to find something that was equivalent to what the government is presently trying to do when it comes to regulating firearms. And so Bruin basically requires lower courts to apply that analysis and for the proponent of the regulation to be able to provide that analogy. And if they can't, then the law is not going to be upheld. Hawaii ignored this and decided, nevertheless, the law can be upheld. And in fact, the only people in Hawaii who are entitled to keep and bear arms are members of the militia or the National Guard, as it's currently.
Go big or go home, right? I guess.
Yeah, it's ridiculous. And so again, another case, right? It's under conference right now. They have a conference scheduled for November 1st to decide whether or not they'll be, what they're going to be doing with the case. The Supreme Court does. So we'll see what happens. But we should be getting some kind of answer out of them in the next couple of weeks.
Yeah, I like the chances of the petitioners there to get that reversed. We shall see. Okay, and then one more petition that we're involved in, and then we'll open it up to questions, is the Boston Latin case in the equal protection space. This involves a school in Boston, obviously, that has gerrymandered their admission standards in order to affect the racial makeup of their student body. We filed an amicus brief in a previous case involving a similar school in Virginia. The Supreme Court denied that case, although there were dissents by some of the justices saying this is a case we ought to take. This is the next opportunity to address that issue. Sometimes the Supreme Court declines a case or two or three, and then all of a sudden grants another case. That's just because sometimes facts might be better, or a vehicle might be better, or there might be different justices on the court. So we shall see whether or not they grant that case. It's been relisted a few times, meaning that they want to talk about it more and more. Of course, that sometimes means that another judge is writing a dissent. So hard to read those tea leaves as well. All right, well, those are the cases that we think you should be watching and making sure that you read Mountain State's materials on. I do want to open the floor to questions. We already have a few. If you have questions, go ahead and drop them in the Q&A box now. The first question, Mike, is for you. And there's a little bit of this in the VanDerStok case about criminals using homemade firearms and what can police do. Do you want to address the idea that a criminal would want to use a ghost gun? I mean, obviously, this is a policy argument, not a legal argument. But one of the arguments that the Solicitor General saved for her reply was the idea that criminals will run a truck through a loophole like this and start using ghost guns more if the Supreme Court rules in favor of our clients. Why would criminals want to use that? Yeah.
Yeah. So our argument is criminals will start not following the law, which is ridiculous. That's what's always so aggravating about these regulations is that the only party that tends to follow the regulations are those who are law-abiding to begin with, who would never use their firearm to commit a criminal act. And yet they're the ones whose hands are increasingly tied by these regulations. The criminals, by their very nature, don't follow the law. And so you can throw as many regulations out there to try to control gun violence, to try to control illegal handguns, to try to control unserialized firearms. And they're not going to follow that. I was a federal prosecutor for 7 or 8 years. And most of that time I was doing gun and drug cases. And these two things went hand in hand. My primary charges were always drugs. And we're talking about large drug conspiracies, but there was always firearms involved in it. I can't think of one case in that 7 years where the firearms had been lawfully acquired. Not one, right? I can't think of one case where the firearms were privately manufactured by the criminals themselves. What happened with most of these firearms is that they had been stolen 10, 15 years before out of some law-abiding citizen's house and passed through 5 or 6 or 7 hands before they got to the criminal who used them for purposes of advancing the drug conspiracy. And so that's the issue here. We have so many laws on the books currently to deal with these problems, to deal with unserialized firearms that people are using in crimes, to deal with stolen firearms, to deal with fill in the blank when it comes to firearms. Apply those rules, charge those people, sentence them to hefty prison terms, make it painful for them. That's how you reduce the use of illegal firearms or the unserialized firearms in criminal activity. You actually have consequences for the criminals. You don't continue to burden law-abiding people. You have consequences for all the voluminous laws that are on the books for those who continue to violate those laws. Period. End of story.
Great answer. Next question is about how a decision in the Ames case would affect Mountain States cases, specifically the investigation that we've launched into the Secret Service and their DEI hiring practices that offer a preference for females and female agents. And it would certainly cast a shadow on those types of efforts, because in that case, we're suing on behalf of males who, under the 6 Circuit's rule or the 10 Circuit's rule, would have to plead extra facts, plead extra background circumstances in order to get their case across the first hurdle to survive a motion to dismiss. We are still in the midst of our investigation. We haven't launched our lawsuit yet, but you ought to stay tuned. We have big things on the horizon, I can promise. The next question is about one of the cases that we haven't talked about, and it's asking, isn't there a major LGBT case on the horizon for SCOTUS this year? The answer is yes. There is a case called Skermeti versus United States out of Tennessee involving transgender operations for minors, which the state of Tennessee has banned. And it's the United States government seeking to have the court find that ban unconstitutional. The 6th Circuit, where Tennessee is, already ruled in favor of Tennessee's ban on transgender operations for minors. The government is arguing that there's an equal protection problem with that and that it's unconstitutional based on sex discrimination. Mountain States isn't actually involved in that case. We don't generally take a position on social issues. We do have cases involving LGBT issues in our Title IX space, often because they involve free speech concerns. In our Title IX cases, we are arguing about preferred pronoun policies, about criticism of males on female sports teams that might be protected, that are protected by the First Amendment. But generally, if there's not a speech issue, Mountain States isn't involved, but it's absolutely true. The Supreme Court does have a case called Skermeti about transgender operations for minors that many people are interested in and probably will be following. All right, I think we're almost out of time, but Ivan, let me give you the last question, and it's about property rights more generally. Do you think that the SCOTUS, the Supreme Court of the United States, is sensitive to property rights, interested in vindicating property rights? I mean, just in the recent history, think of like Cedar Point and other cases where the court has expanded the ability for people to bring takings claims. What do you think about the current Supreme Court's, are they attuned to property rights issues more broadly?
I'm enjoying watching the World Series, so I appreciate a tough pitch. The answer is, I think so, yes. As I mentioned with the Utah v. US case, I think this court has shown that it is willing to take on some tough cases, some tough questions, even if they defy maybe the current regulatory environment and developed over many decades. I think the McGirt case, for example, would be a good example of that, which is not guarantee, of course, any future outcome for a case, or I don't want to overread that to say that every case is going to be a good case. But I do think this court is very attuned to the idea that there are fundamental rights. They're in our Constitution and the amendments, right? And just because something's been wrong for a while, doesn't mean it has to stay wrong.
Right.
So I think that's how I would answer that question. Hopefully,
Yes. Okay. And the last question is from Justice Clarence Thomas, who said, "I like the NEPA doesn't mean NOPA tagline.
Oh,
Why didn't you write
right?
that down when I said it?"
No, it's all in here. It's all in here. Yeah.
All right. We'll close on that note. Thank you to all of the viewers today on our Teams meeting. Thank you to all the people who asked questions. We look forward to seeing you at our next monthly webinar. Thank you to Mike and Ivan for being our guests here today. Terrific insight, really great answers to our viewers' questions. This was our October So Neighbor Ask webinar. We will certainly be doing a November series. So for those of you who are interested in being a part of our email list or otherwise taking a look at our materials and our continuing series, go to mslegal.org. We're very thankful to have your support and attention to our webinar today, and we look forward to seeing you next month. And with that, we are adjourned.